Okay, perfect. Okay, so we're going live. Good luck, everyone.
Thank you. Good morning, everybody. Welcome back to the second day of our European event on the occasion of C189's 10th anniversary. My name is Karin Pape. I'm the European coordinator for the International Domestic Workers Federation, IDWF. I'm welcoming you to panel number 3 with the title Guaranteeing the Effective Enforcement of Domestic Workers' Rights. This is an important topic for us in Europe, as we often don't have the problem of a lack of a legal framework for domestic workers, although there are loopholes. Probably some of our panelists will refer to that, but the main problem is the lack of implementation. Therefore, I'm very much looking forward to our speakers who will share with us national and local initiatives aimed at improving the enforcement of rights for domestic workers, in particular with regard to access to social protection, domestic workers' professionalization, and health and safety measures. However, let me first share with you some housekeeping information, what you can see on the screen. So it's the same as yesterday, so it's nothing new for those who already joined us yesterday. This event will be recorded and made available. Your microphone will be muted. For questions, please use the Q&A button on the control bar and feel free to share your comments in the chat box. Very important, interpretation will be provided during the event in English, French, Italian, German, Polish, Romanian, and Spanish. And in order to choose your preferred language, please use the button on the lower part of your screen in the Zoom panel. So if you need support, please don't hesitate to write it in the chat. So let me just go on with my, So this is a short overview of our speakers we are going to listen to in a second. And I'm not going to introduce you them now, but if you agree, I will take the speakers in the order of the list we are seeing on the screen, and I will give a short introduction to the panelists before they speak. Please be mindful of time. Apart from our first speaker, who has 10 minutes, all others have 8 minutes for their presentations, so that we still have some time for question and answer session. 1 minute before your time is up, I wanted to uphold a sign, but I don't know if this will work anyway. Otherwise, I will shout at you that to be mindful of your time. And now, without very further delay, and let me stop sharing my screen, I'd like to introduce to you Mrs. Vera Pavlou. Vera Pavlou is a researcher from the School of Law at the University of Glasgow. She wants to share with us her knowledge on how to use EU law as a source to challenge national provisions and practices that make domestic workers vulnerable to exploitation. Very important, very kind of interesting approach, I think. Just to mention that Mrs. Pavlou's doctor thesis was on migrant domestic workers in the EU, the role of constructing vulnerability, and it was awarded in 2017 with the Mauro Cappelletti Prize for the best thesis in comparative law. I also want to highlight that Mrs. Pavlou contributed with an article to the report, which was put together for this event, in which she highlights EU law in connection with the regulation of working time. Mrs. Pavlou, the floor is yours.
Thank you very much, Karin, for this very nice presentation, introduction. Let me share my screen with you. Okay. So as Karin mentioned, the topic that I would like to talk to you about today concerns the applicability of EU labor law sources to domestic work and how we could use EU labor law sources in a more efficient way, in a better way, to improve domestic workers' rights in the EU. Because it's a very wide topic and the EU labor law contains a lot of different sources, my focus here today will just be on working time. But of course, we can take the argument and look at different areas of EU law as well. So first, a brief outline of how I will structure my presentation. I will start by explaining what is the importance of EU working time law for domestic workers. Then I will give you a brief introduction to EU working time law for those of you who might not be familiar with it. Then I will give a few examples of mismatches that I have found in my research on domestic workers with national law, so mismatches between EU working time law and the level of protection provided by national labor regimes. And then finally, I will conclude by looking briefly into the role of different actors in promoting the application, the enforcement, if you like, of EU working time law on domestic workers. So why I think EU working time law it's important for domestic workers. It's an important resource to improve their protections and at the national level. That first of all, we have the principle of the supremacy of EU law over national law. So this means that whenever there is a mismatch between what EU law stipulates and what national law provides, then national rules will be disapplied in favor of the application of EU law. This is very important because it means that, of course, directives need to be implemented, but we don't have this process of ratification that we might have at the ILO level, that many times it's a very political issue and states might lack political willingness to ratify a convention. Here in the area of EU law, we don't have this issue. Then another important point is that EU working time law applies to all workers, including those who are undocumented. And even though we don't have a specific judgment of the Court of Justice looking specifically at EU working time law and its applicability on undocumented migrants, we have another judgment in another area of EU social law, the Tumor judgment, which looked into the issue and basically said that EU social law sources do not distinguish between undocumented workers and documented workers. So they apply to everyone who works in the EU, specifically here working time. Then in the area of working time law, we have a broad definition of workers. So who is entitled to these protections is constructed broadly at the EU level, and moreover, the notion of worker has a status of autonomous EU law notion. This means that it is defined at the level of the EU and it's binding on member states, so that member states cannot have a more restrictive definition of who is a worker that can enjoy the different protections and rights in the area of working time. So the definition, as you can see, I just gave there a sentence. It's quite broad. It means that anyone who provides during a certain period services for and under the direction of another in exchange of remuneration. So we might have even a few hours, people who work few hours or on a very low remuneration and so on. So this will prevail over national definitions that might require a higher threshold. So from all these, the insight that I want to give is that EU working time law, I think it's a very important resource for domestic workers, but it has been underutilized until now, mainly because there was this misunderstanding, if you like, that EU working time law does not apply to domestic workers, but this has recently been overturned through research, but also through judgments of the Court of Justice. So now a brief introduction into EU working time law. First of all, a caveat here that I need to mention. It's important to say that not all the problems that we have been discussing also yesterday can be addressed through EU working time law. For example, yesterday we heard that one of the problems that domestic workers face is that they might not work enough hours to make a decent living. This cannot be addressed through EU working time law. However, there are important rights in other areas that can be useful. And I will focus here on the EU Working Time Directive that, as some of you might already know, it has a health and safety dimension. So it was adopted to implement health and safety rules, but even though it has this health and safety dimension, it's a dignitarian understanding of health and safety. It's an understanding of health and safety that seeks to protect workers' dignity. So it's not just a technical issue of applying health and safety standards. So briefly, the EU Working Time Directive provides several rights for workers, so limits to weekly working hours, daily rest breaks, minimum daily rest, minimum weekly rest, paid annual leave, and also special protections for night work. And it's important here to mention that limit to weekly working hours, daily rest, weekly rest, and paid annual leave are characterized by the European Court of Justice as fundamental social rights. So this means that they have to apply to everyone, and any kind of exceptions that we find in national law have to be construed, have to be understood narrowly, because these are fundamental social rights. Then, of course, another issue that is very important for domestic workers, the issue of on-call, which is not regulated explicitly in the directive. However, there is important case law, the Court of Justice, that had looked not on the issue of domestic workers, but of other workers into the issue of on-call, and has established several principles that are protective of workers, and these apply to domestic workers as well. So overall, just briefly, the main point from these different judgments is that when the employer requires a worker to be present at a specific place, which can be the workplace, or it can be another place. Imagine, for example, a domestic worker who has to accompany her employer during the employer's holidays, for instance, that when the worker is there available to respond to calls for work, that should be considered working time, and it will count towards the maximum limits, and it should be remunerated, of course. And these hours should be considered working time, even if there is a possibility to rest. So what matters from the perspective of EU law is the worker's autonomy to use her time freely as she wants, without having to respond to calls for work from the employer. And then, since we are a panel here today that focuses on enforcement, then in the area, of course, working time legislation has a lot of issues with enforcement, not just for domestic workers, but for everyone. But there is a recent judgment of the Court of Justice, which is important in this area and establishes the employer's duty to keep records of working time. And this is inferred precisely from this dignitarian purpose that EU working time law has for workers. And of course, this applies to the employers of domestic workers as well. Now, looking at what national law provides, here I will just give three very brief examples from my own research, but of course there are many other countries that one could look into and probably find mismatches in the way domestic workers are treated, either through specific legislation or through general labor law rules or collective agreements. For example, in Cyprus, which is the country where I come from, the transposition of the Working Time Directive has been word by word. So Cyprus basically just translated the directive and applies it. At the same time, however, the government has a special migration regime for non-EU domestic workers, which contains exclusions for domestic workers' rights, including also on working time. For example, there is no regulation of overtime or on call, which leads to practices of migrant domestic workers being constantly available to the employer without any remuneration for that time.
Excuse me, Vera.
Yes.
You have 1 more minute.
Okay.
Thank you.
Then I will leave this here, and I will just move to my final slide on the role of different actors. So I think it's very important that EU institutions, especially the European Commission, that is responsible to monitor member states' implementation of the different directives, to have an explicit policy of monitoring also compliance of member states with these rules for domestic workers as well. So it's important to have an explicit policy of monitoring how member states are complying. Then, of course, there are roles for national labor law enforcement authorities. We know, of course, that labor inspection in private households is very problematic. It's very difficult to carry out in different settings. However, national labor law enforcement authorities could organize campaigns informing both employers and domestic domestic workers of their rights and obligations under EU law. So to include the obligations of EU law into their campaigns, into different enforcement strategies. And then, of course, for local actors, local trade unions and advocates for domestic workers, it would be useful to start looking also into EU law sources and using the strategy of invoking compliance with EU law as a way to challenge more restrictive national practices or national rules. So thank you very much for this opportunity, and I look forward to the discussion.
Thank you very much, Vera Pavlou. And I can totally confirm what you said at the beginning. When we look at domestic workers' rights, also at the European level, actually we are concentrating on the convention and never really take into account that we have EU laws which we can use. So I think that is a learning, at least I take away from your presentation. So thank you very much for this. The next speaker on the list is Mrs. Teresa Pargana. She is representing the Portuguese Ministry of Labour, Solidarity and Security. She is the head of division for studies, conception and technical support to inspection activity, working conditions authority. We heard yesterday from Mr. Cabrita, the Secretary of State for Labour in Portugal, that the government plays a crucial role in ensuring protection for domestic workers. So I'm therefore particularly happy that Mrs. Pargana will share with us some good practice examples around the problem of labor inspections. This was one of the most hotly discussed topics during the ILO negotiations, and it is still a key argument from governments when they say they cannot ratify the convention. I'm sorry. We are therefore very much looking forward to Mrs. Pargana's presentation, promoting better working conditions on the domestic work sector. Madame Pargana, the floor is yours.
Hello, good morning to everyone. Thank you very much for your kind words. So I'm going to try to share my screen. Okay. Okay, is that okay? Yes? Okay, so I am a labor inspector for 20 years, and I'm in this moment responsible for a technical unit that gives technical support to labor inspectorate to our local branches. And what we do and what are our concerns about domestic work. The rule of labor inspection is to promote better working conditions according to ILO conventions. It's what we do. And how we do that? We do that through the complete control and monitoring the enforcement of labor standards, and also at health and safety. Portugal ratified the ILO convention in 2015, entered in force in 2016. But before that, we have already have a specific regime for domestic work since 1992. And this regime has rights, stipulate rights to domestic work related with the work contract and related also with health and safety. So what we do, we promote awareness, information, as I'm going to speak, and we also enforce in order to achieve better working conditions. So we are generalists because we have this competence on labor relations, on the work contract, and also in OSH. And what we want is to promote better working conditions in all sectors. So our competence is not only in the domestic sector, but all sectors, which include, of course, domestic work. So what we have been done in this field of information, we provide information to raise awareness about rights and duties of domestic workers in order to increase the legislation knowledge. As I said, we have 32 local branches, and we give presential information to workers and employers. Any domestic worker or employer can go to a local branch and have information about the duties and the rights. And if they want, they can come together. It's already happened, the domestic worker and the employer, in order to clarify what rights and what duties the both parts have. So, and we try to promote conciliation between them when there is a conflict. We have also a hotline 5 days a week, and this what there is labor inspectors that give information about everything what is related with the work contract, and also, of course, if there is doubts about that. We have also a chatbot in order to clarify with some questions and some answers, and we have specific questions and answers to domestic work also. We have forms at our website, forms where employers and domestic workers can make questions, and we give written answers. And we have also forms related to employers' obligations. For instance, communication of a foreign worker. We have a model, a form for that in our website, and other one. As I said, we provide written information, and through our hotline. We have also a simulator for calculating remunerations. In our website. In Portugal, when a contract ends, the worker has rights for the end of that contract, and we have a simulator to calculate these remunerations. So it's our information activity related to domestic work, because what we want is the accomplice of the law. It's not just apply penalties, it's just to inform in order to comply the law. But sometimes that is not possible, and we must adopt coercive procedures that I'm going to speak about. We also develop, as Vera said in the previous panel, awareness campaigns. We develop a campaign with a focus to tackle abusive and illegal undeclared work. It's not specific for domestic work, but involve domestic work. And our goal is to involve the social partners, employers and trade unions. The representative of employers in the field of domestic workers, it's not relevant, but we have a trade union that represent other sectors and also domestic work. And our targets were vulnerable groups, migrants, women, and we know that domestic workers are the majority of them migrants or women. So this campaign involved these kind of workers. And what we have done some information sessions. We involve Social Security, High Commissioner for Migrations, the Police for Foreign Affairs, and we develop information sessions, as I said. We give training to labor inspection, guidelines to labor inspectorates, and we develop target inspections related with tackling undeclared work. We have flyers in 5 languages, Portuguese, English, French, Russian, and Romanian, and we disseminate this information. We try to disseminate in the radio advertisements, digital, written press, and our social partners also. related to inspection, related to enforcement. We have complaint mechanisms. We have a form in our website when workers can present complaints about illegal situations. The situations more frequent that we have, it's failure of pay of wages, Christmas bonus, vacations allowance, working overtime, holidays, social protection sometimes, and the compensation for the end of the contract. This is the contents that people ask more and have more doubts. When we receive these complaints, we can contact the employer if the worker allows us, because these complaints are confidentiality. But if the worker gives the authorization, we can contact the employer by phone or by email, or we can make also a notification to request documents. And what documents? The working contract, the receipts, the proof of social discounts, a work accident insurance in Portugal, it's mandatory. So we can ask for documents that prove that the situation is okay. If the situation is not okay, it's irregular, we invite the employer to regularize the situation, and if he doesn't regularize, we can apply penalties. We have here in the domestic sector, as you know, a constraint, because we only can visit the workplace when the employer gives the consent, on where when we have a court order, a judicial mandate. But if we want to, we can go at the door of the worker, and we can ask some questions at the door, but we can't enter if we don't have the employer consent or the judicial order. But which, as I said, we try to solve at phone, through email, and with our notifications to prove that the situation is regularized. So when we find some the infringements related to social security, we participate to other institutional, like social security, tax administration. And as I said, when the situation is not solved, we can apply penalties to the employer in order to achieve the enforcement of workers. So thank you very much. And if you have some doubts, some questions, of course, you can ask me. Thank you very much.
Thank you so much, Teresa Pagana. This was very, very interesting indeed, and it shows that a lot can be done by government without having to enter the private home necessarily in the first place. So I think we will circulate this very broadly, I think, or use this as a good practice example of Portugal. So thank you very much for that. My next speaker is Monsieur Baptiste L'Enfant. He is a CEO at Iperia. And Iperia is a platform for the professionalization of domestic services, targeting the employers of domestic workers. It provides research, training modules, and other professional support for the employers of domestic workers. Professionalization of the domestic work sector is an important topic, in particular in European debates, as this is always seen as a means to improve working conditions, pay rise, and so forth. So we are eager to hear the role of professionalization of domestic work in connection with increasing the working conditions for domestic workers, but also for better services for the private households, with a special focus on the certification of skills. So therefore, I'm now inviting Monsieur L'Enfant to speak about training and certification, a key for domestic housekeepers' professionalization. Monsieur L'Enfant, the floor is yours.
Merci Madame Papeux, merci à tous et bonjour à tous. Merci vraiment de cette invitation et nous donner l'opportunité de pouvoir quelque part montrer à voir certains exemples de bonnes pratiques, et particulièrement évidemment en ce qui me concerne en matière de professionnalisation par rapport à ce que vous avez dit dans le cadre de cette courte présentation, moi je voudrais revenir très très rapidement sur le sens d'installer finalement une politique de professionnalisation, alors qu'elle soit à l'échelle locale, nationale, et je le souhaite de tout cœur à l'échelle européenne et pourquoi pas internationale, puisqu'on est dans le cadre d'une conférence internationale. D'abord, c'est véritablement pour apporter une dimension professionnelle à l'activité. Ça a été dit d'ailleurs dans le rapport de l'Organisation internationale du travail sur le travail décent pour les employés familiales. Je le redis, c'est peut-être une évidence aujourd'hui, mais il n'y a rien de naturel à exercer ce type d'activité, ce type de métier, d'autant plus quand on est une femme. Et donc, la professionnalisation apporte ce cadre professionnel et quelque part met fin à ces questions d'acquis culturel ou d'inné naturel qui pourraient toujours être présents dans la tête de certains. Le deuxième élément qui est majeur quand on parle de professionnalisation, c'est évidemment de donner une image différente du métier avec ce caractère professionnel, et ça permet de changer à la fois le regard de la société et, pour l'avoir vécu depuis de nombreuses années, également le regard des professionnels eux-mêmes qui parfois se dévalorisent. Et donc la professionnalisation est un vecteur puissant pour changer cette image. Et ensuite, le dernier levier qui est très important autour de la professionnalisation, c'est évidemment la question d'intégration et d'insertion, et de pouvoir aussi à chacun de s'intégrer dans un projet de société. Et tout ça va participer évidemment de la mise en visibilité de métiers, de compétences qui sont parfois encore finalement dans l'invisible. Alors je voudrais, avant de parler d'un programme européen que nous avons coordonné il y a maintenant 2 ans, donner un peu la manière dont les choses se sont faites en France, puisque pour nous, cela remonte au milieu des années 90, donc c'est un sujet très ancien, avec à la fois un investissement très fort des partenaires sociaux, c'est-à-dire des représentants des ménages employeurs, puisque le modèle, on va dire, dominant en France, ce sont des particuliers qui emploient des salariés, donc ces représentants des ménages employeurs, avec les représentants des salariés qui ont véritablement construit par convention, on va dire, les droits sociaux concernant la formation professionnelle et de ce fait installer une politique au niveau national sur ces enjeux de professionnalisation. Et concomitamment à cela, Hyperia a été créé au milieu des années 90 avec cette mission finalement de faire reconnaître un certain nombre de métiers, de compétences de ces salariés qui travaillent à domicile, et en particulier les métiers d'employés familiaux, puisque le premier travail a consisté à certifier, à faire reconnaître les compétences d'une dizaine de personnes qui travaillaient au domicile d'autres personnes sur des activités dites domestiques. Et donc aujourd'hui, quand on parle d'une politique de professionnalisation nationale, on s'intéresse à 3,4 millions de personnes qui emploient 1,4 million de salariés. Donc les enjeux sont évidemment colossaux. Et donc cette Hyperia qui a été créée dans les années 90, qui est donc la plateforme nationale de professionnalisation de l'emploi à domicile, a 3 grandes missions. D'abord, une mission d'observation des métiers et des compétences et de regarder comment les besoins évoluent à domicile pour mettre en place les programmes de formation adaptés, installer des dispositifs de certification professionnelle, donc qui permettent de reconnaître, d'identifier et de reconnaître ces compétences et de leur donner une valeur. Vous en avez parlé, puisqu'aujourd'hui, c'est les personnes qui disposent d'une certification professionnelle dans la convention collective des particuliers employeurs et de l'emploi à domicile ont une rémunération qui est un peu plus élevée. Et enfin, troisième dimension, c'est de pouvoir offrir un accompagnement personnalisé à ces ménages employeurs, à ces salariés, en matière de formation professionnelle. Et je voudrais évidemment mettre en visibilité quelque chose de très concret en matière de droits sociaux concernant la formation professionnelle, c'est qu'à partir du moment où vous travaillez chez un particulier employeur, quel que soit le temps de travail et quelle que soit votre ancienneté, vous disposez de 58 heures de formation professionnelle dans ce qu'on appelle en France le plan de développement des compétences, et qui permet aux salariés de partir en formation et d'être rémunérés. Donc 58 heures tous les ans. Et pour traduire ça concrètement en chiffres et on va dire un peu en résultats, en 2020, c'est plus de 70 000 parcours de formation qui ont été engagés dans ce cadre. 70 000 parcours, c'est beaucoup mieux qu'en 2019, puisqu'on était autour de 60 000 parcours, ce qui veut dire que même en temps de crise, aujourd'hui, il y a un certain ancrage au niveau de la professionnalisation au niveau national. Et donc, fort en fait de cette expérience et de cette expertise, évidemment, l'objectif, c'est d'avoir une dimension beaucoup plus large désormais et de pouvoir s'intéresser au moins à la dimension européenne dans un premier temps. Et ça a été traduit dans le cadre d'un programme qui s'appelle PRODOM, programme qui visait en fait à réfléchir à la mise en place d'une certification européenne pour le métier d'employé familial, les domestic workers, dont on parle depuis le début de cette table ronde. Et donc, en bref, ce programme a réuni 7 partenaires, 6 partenaires plus un partenaire associé, donc de France, d'Italie et d'Espagne, avec encore une fois la perspective de faire un diagnostic de situation sur le métier d'employé familial, de créer un parcours de formation et d'ouvrir la réflexion sur une certification professionnelle. Donc, sans m'étendre sur le sujet, il y a pour moi 2 éléments qui sont majeurs autour de ce métier et peut-être qui ne sont pas assez mis en valeur et que l'on a finalement travaillé à travers ce programme. Au-delà finalement de la dimension professionnelle, au-delà de la dimension de la certification de compétences, pour moi, il y a 2 éléments qu'il me semble important de souligner. D'abord, à partir du moment où ces personnes acquièrent un certain nombre de compétences dans le cadre de la formation professionnelle, elles peuvent être des passeurs de compétences au sens où elles sont au domicile et elles peuvent transmettre un certain nombre d'évolutions de notre société. Je vais prendre un exemple très concret puisque ça a fait partie des travaux, ce qu'on appelle notamment les compétences vertes. À partir du moment où vous êtes en capacité d'adopter des pratiques qui soient plus respectueuses de l'environnement, de l'être humain, eh bien, vous pouvez avoir ces acteurs qui, à domicile, transmettent un certain nombre de nouvelles pratiques, de nouvelles orientations qui sont liées à l'évolution de la société. Le deuxième élément aussi, c'est à partir du moment où ces personnes sont à domicile et sont en lien avec parfois des personnes du domicile, elles peuvent être des acteurs de la prévention de la dépendance. Et ça, c'est très important. Elles peuvent repérer les premiers signaux de la perte d'autonomie. On en a fait l'expérience en France dans le cadre d'une étude que l'on a menée. Et donc, à partir du moment où ces acteurs permettent de prévenir la dépendance, eh bien, ça permet aussi de donner de la valeur davantage à ce métier. Voilà ce que je voulais vous dire au niveau de la professionnalisation, au niveau des droits sociaux. Simplement aussi peut-être rappeler quelque chose qui nous anime au niveau européen, c'est le premier principe du socle européen des droits sociaux, que je vais lire très rapidement en conclusion de mon propos. Mais toute personne a droit à l'éducation inclusive et de qualité, à la formation et à l'apprentissage tout au long de la vie, afin de maintenir et d'acquérir des compétences qui lui permettent de participer pleinement à la vie en société et de gérer avec succès les transitions sur le marché du travail. Évidemment, c'est un principe qui nous anime et je souhaite qu'au niveau européen, on puisse continuer de progresser sur cette question de professionnalisation. Je sais que Haute-Boisseuil nous suit dans le cadre de cette table ronde. Nous sommes membres également de la Fédération européenne des emplois de la famille et dans le cadre d'un livre blanc, nous avons fait quelques propositions en matière de professionnalisation et de droits sociaux en matière de formation professionnelle. Voilà, je vous remercie de votre écoute en espérant avoir été le plus synthétique possible dans le temps imparti et le plus clair possible. Merci.
Indeed, you were very clear and also kept the time. So thank you very much for that. And so it reminded us that maybe in particular for Europe, I don't know, but that the aspect of professionalization should not be underrated. And what I take from your presentation is first to start with acknowledging the skills that are already there before assuming that domestic workers need to acquire skills. This is also a little bit debated at the international level, that there is a lack of recognition from already existing skills. So, and it is very encouraging to hear that the certification in France resulted to better pay and generally working conditions. And also very interesting that you're looking into the European, maybe in some sort of European certification. So this is to bear in mind when we further do our work in our respective organizations. So thank you very much for that. The next person on the panel is Mr. Pieter van de Weide. And he is the director of the Service Voucher Sectoral Training Fund in Belgium. How could we have a panel like this without referring to the Belgian model, which is widely seen as the gold standard in Europe how to regulate domestic work. So Peter van der Weyde is concentrating in his intervention on ensuring domestic workers' well-being and safety at work. This is an important but often underrated issue to ensure good working conditions for domestic workers. So Peter van der Weyde, the floor is yours.
Thank you, Karen. I will start with sharing my presentation. Just let me know if it's okay. Okay. Title of the presentation, I use the title, Respect is a Two-Way Street. Since I only have 5 minutes and I could talk about 5 hours or 5 days about this topic, I will try to keep it short in certain ways. I feel a lot of pressure because the president of this session said we are the gold standard in Belgium. Well, we try to be, and we've been here for about 14 years. But in 2017, the employers and employee representatives started with the Sustainability Fund, in which the main goal was making the work of our domestic workers in the service voucher system sustainable. In which we turn this a bit by creating respect for the job. I think you will all agree with me that if you look at the appreciation of the work of domestic workers, then we still have a long way to go. We have different terms that we use for domestic workers, and most of them have a negative undertone. So what we try to do is put in a positive word for all the work these people do and try to name them as they should be, domestic workers, in Dutch, huishoudhulpen, assistants in the house, for all those people. And this is the main goal of the fund that was created in 2017. And then we looked at who should be involved in this fund. Who should we try to reach to gain the respect that is widely needed for the job of domestic worker? And of course, we come to the two most important parties, the domestic workers themselves and the customers. We say, well, the one needs to respect the other and the other way around. But when we looked a bit closer, and in Belgium, we have a situation in which we have other parties, especially the companies and the management of the companies, which provide I would say, the contracts for those domestic workers and the environment in which they can work safely. Well, these are important parties also because they need to be also respecting the domestic workers' rights and, of course, also the customers' rights. That's pretty normal. But then we also saw a third party or fourth party, which is a supporting staff, because it's not just the management or the company that needs to be involved. It's also the supporting staff, the people who make the daily rosters for those domestic workers, who have contact with the clients, who are there when domestic workers have problems with their clients or other problems. Because sometimes in Belgium, supporting staff are seen as domestic workers or social workers sometimes, because all of the problems domestic workers have sometimes, and they go to the supporting staff. And last but not least, of course, we have the trade union representatives. We have in Belgium actually companies ranging from companies with about 20 domestic workers with contracts to up to 5,000 workers. So actually, we have very small and very large companies. This gives a whole new meaning to the sector, because those large companies have sometimes a very well-structured HR policy. The small ones are very close to their domestic workers and also provide good service towards those people. But if you look at the picture now and you see those two arrows, well, this isn't correct anymore. It is no longer a two-way situation. It is no longer a two-way street. It is a roundabout with people coming from everywhere, all parties involved, which have to take into account all the rules and regulations and also have to show respect for the work those domestic workers do. So how did we go about the whole job of creating respect for the job of domestic workers? Well, first of all,
excuse me, Peter.
Yes?
Peter, could you please try to be a little bit quicker because we also see the videos, right?
Okay. Yes. Okay. So we started with a study, and the study, well, was plain, very simple. We asked about 4,000 domestic workers what their situation was, and to our surprise, about 90% was very happy with their situation, but there were some issues. And we tried to tackle those issues with training of the domestic workers, consultants, and management. Issues were respect for the rules and regulations. Sometimes clients just simply ask to paint the kitchen, which is not allowed. The material, also people provide, or clients provide the material to clean the houses with, but people weren't aware of those materials needed. And also respect for the person themselves. We have a lot of women in the sector, about 89%, and also there we feel there's sometimes a problem. So we try to raise awareness through coaching and training by consultants, management, and workers. Fourth topic, the third topic, the coaching of domestic workers, and that's a bit I heard from Mr. L'Enfant. In Belgium, we set up a system where I would say domestic workers with a lot of experience are now able to coach those with less experience or who need help. So at that point, we try to elevate the position of the domestic workers with experience and help them by training others. And then last but not least, and Karen was also referring to that, we also do a yearly campaign towards the clients. We have been doing this for 3 years. We will do this for furthermore 3 years. And the first year we were talking about the good material you need to provide for the workers. Then the second year was the professionalism of the sector, and that's already something I heard also in the previous presentation. And this year we were really talking about respect, and respect comes also in the form of material or other things. And I think now is the time, Karen, that you will show the 2 small videos, because respect is a roundabout and no longer a two-way street.
Wonderful. Thank you very much, Peter. And without further delay, please, can I ask the technical support people to share the video? Or the 2 videos, I have to say.
They're very short.
Are you uploading the second one?
Yes, just 1 second, please. Thank you.
Wonderful. Thank you. Thank you very much. That was a very, very nice and very quick overview of what you are doing in Belgium from a little bit of another perspective. And You mentioned, Peter, also the important role, as it was mentioned before, actually, by the other panelists, the involvement of the trade unions, and but the trade unions, they always, or they preferably, they need a counterpart, which are the employers. So we are now moving to that side of the coin of social dialogue, because Massimo De Luca will be giving a presentation of the role of bilateral bodies in the domestic work sector as a key factor in training and prevention. Massimo De Luca is the director of the Domina National Observatory on Domestic Work in Italy, and Domina is the Italian National Association of Families as Employers of Domestic Workers. So Mr. De Luca was Domina's delegate to the drafting and revision of the National Collective Agreement on the National Joint Commission. And so he will highlighting for us as a real specialist being involved in social dialogue at the national level about the role and the Italian experience. So please, Massimo De Luca, go ahead.
Buongiorno a tutti, grazie Karen per la parola. Innanzitutto mi preme fare i complimenti per l'intero impianto della conferenza, perché stiamo cercando tra ieri e oggi di capire qual è lo stato di salute della 189 e soprattutto anche di capire quelle che possono essere le grandi prospettive di sviluppo per questo settore. Quindi vi faccio a tutti i miei complimenti. Prima di entrare nel merito del mio focus, desidero darvi un paio di numeri che ci permettono di fotografare bene quello che è la situazione del lavoro domestico in Italia e capire che cosa sono e a cosa servono ovviamente gli enti bilaterali in Italia. La settimana scorsa sono usciti gli ultimi dati INPS, che è l'Istituto Previdenziale Italiano, che ha censito nell'anno 2020 ben 920.000 lavoratori domestici regolari. Se noi prendiamo questo numero e lo compariamo al 2019, quindi all'anno prima della pandemia, scopriamo che nell'anno della pandemia, a saldo di tutti i licenziamenti, in Italia ci sono stati ben 64.000 unità in più rispetto all'anno precedente. Quindi al saldo dei licenziamenti abbiamo avuto un aumento esponenziale di quello che è la regolarità di questo settore, ovviamente non tenendo in considerazione quello che in Italia è avvenuto, cioè la regolarizzazione, che comprende altri 170.000 rapporti di lavoro. A questi numeri, se noi sommiamo anche, teniamo in considerazione quello che è l'irregolarità nel nostro settore, quasi oltre il 50%, arriviamo a circa 2 milioni di lavoratori domestici, regolari e irregolari. Questi numeri, ovviamente, per la particolarità del settore lavorativo italiano, sono numeri che vengono da un'assunzione diretta tra famiglie datori di lavoro domestico e lavoratori. Quindi in Italia non è che c'è un grande mercato delle aziende, le assunzioni sono direttamente realizzate dalle famiglie. Quindi questo che cosa significa? Che se è vero che il rapporto a 1:1, possiamo dire che intorno al contratto collettivo italiano ruotano circa 4 milioni di soggetti privati. Questi numeri sono fondamentali, sono importanti, perché danno una chiara immagine della situazione italiana del settore, perché il contratto collettivo del lavoro domestico in Italia, se lo vediamo dal punto di vista dei lavoratori, si colloca al terzo posto tra i contratti collettivi più utilizzati in Italia. Se lo vediamo invece dalla parte datoriale, si colloca al secondo posto. Questo è giusto per darvi un paio di numeri, per farvi capire quanto è importante il contratto collettivo in Italia e soprattutto la centralità del nostro contratto all'interno del settore lavorativo. Il contratto collettivo, vi condivido questa slide che mi aiuta ad illustrare meglio quello che vado a dire. Il contratto collettivo nazionale è siglato da 6 associazioni nazionali, 2 che sono datoriali, sono Domina e Fidaldo, quella che vedete segnate con le righe blu, e poi dalle 4 associazioni sindacali più rappresentative, la Filcams CGL, la FISA, SCAT e CISL, la Wiltux e la Federcorf. Queste 6 associazioni sindacali ovviamente hanno realizzato, stanno portando avanti quello che è l'insieme dei diritti e doveri all'interno del contratto collettivo. Un contratto collettivo che ha una storia molto lunga, oltre 50 anni, ed è proprio grazie a questa lunga storia che ha permesso di maturare e sviluppare il settore prima ancora che intervenisse la Convenzione 189, dando la possibilità infatti allo Stato italiano, quando è subentrata la Convenzione, di poter essere il primo paese in Europa a ratificarlo e il quarto nel mondo. Questo sviluppo e questa maturità del contratto collettivo ha permesso negli ultimi 10 anni anche di poter istituire 2 enti bilaterali, ovvero un ente che si occupasse di welfare integrativo e un altro ente bilaterale che si occupasse di formazione. Il primo si chiama Cassa Colf, che è quello che vedete con la casetta rossa, il secondo si chiama Ebbing Colf, che è quello con la casetta blu. Cassa Colf si occupa dei servizi sanitari integrativi aggiuntivi, ovviamente aggiuntivi rispetto a quello che già lo Stato italiano offre, considerando che in Italia la sanità è pubblica e c'è un libero accesso. In questo caso parliamo per i lavoratori domestici, quindi solo e esclusivamente per i lavoratori domestici regolari, una forma di integrazione, se vogliamo, di sostegno al reddito, perché parliamo di rimborso al ticket, rimborso per tutte le prestazioni sanitarie integrative realizzate all'esterno degli ospedali, quindi privatamente, visite oncologiche, visite odontoiatriche, diarie in case di ricoveri, sostegno alla maternità e alla malattia. Quindi Cassa Colf ha anche il ruolo di cercare di colmare quelle che sono le lacune attualmente da parte dello Stato. È una realtà molto giovane, ma è una realtà che sta diventando sempre più forte ed importante per tutto il panorama nazionale del sistema lavoro domestico italiano. A questo si sposa anche l'egregio lavoro fatto da Ebbing Colf. Anche qui Ebbing Colf ha l'obiettivo, sempre con la sinergia, sotto la regia delle 6 associazioni firmatarie del contratto collettivo, di creare piani di formazione di natura nazionale. Parliamo di una formazione qualificata in questo caso, poiché Ebbing Colf ha avuto, diciamo...
Excuse me, Massimo, could you please wrap up? We are already a little bit behind the time. That would be great, thank you.
Certo, questo è giusto per darvi, possiamo anche concludere qua, nel senso che è importante anche dire che il sistema Italia, proprio grazie alla bilateralità, sta crescendo tantissimo, una bilateralità che ha come funzione, cioè che mi preme anche qui dire che non ha non sono 2 enti pubblici, ma sono 2 enti privati che non ricevono finanziamenti, in questo caso pubblici, ma sono finanziati dai contributi delle famiglie e dei contributi da parte dei lavoratori, quindi finanziamenti direttamente dal basso, e che hanno ovviamente avuto il pregio, come abbiamo visto soprattutto nell'anno della pandemia, di creare dal basso una grande rete sociale di intervento che sta rendendo il lavoro domestico in Italia un lavoro domestico sicuramente molto più equo e molto più solidale nell'ottica ovviamente della regolarità. Grazie.
Thank you so much. It is, we yesterday heard from actually, she is my executive committee member in the IDWF, from Wendy, from Philcams, of course, about the collective agreement. It's so good to hear the other side and the very well functioning, is my impression, social dialogue in the sector. And what I take away from your presentation, Luca, is that there is even more needed, that you need to have a comprehensive kind of national system which really takes care of the particular situation of domestic workers. And so thank you for sharing that good practice model. So last but not least, I have on my list Mrs. Raluca Painter. She is the head of the unit for labor market education, health and social services at the Directorate General for Structural Reform Support, short DG Reform, of the European Commission. Very, very long title. Mrs. Painter has been concentrating on aspects of job growth by enabling access to finance for companies and increasing investment opportunities for investors. And she has been concentrating very much on the PHS politics. And of course, we also have to talk about money. So, and it's not the least important, but some of the most important topics. So please, Raluca Painter, you have the floor.
Good morning. Thank you very much. And first of all, very happy to be here and listen to the very interesting debates and the different perspectives. Also noticing the call for some action at the European level in some respect. And my intervention here today is simply to point to a service which exists within the European Commission for 5 years. So it's quite a new one, but a very practical one, because support for reforms, this is what we're doing. This is what I'm in charge of in the area of labor market policy, social services, and so on. And I would say the main features of the service is that it's tailor-made to the specific needs of a member state or a region within a state. And it is upon demand. So anytime a ministry from a member state wants support in order to design a reform or implement a reform, we are there to provide that support. And I would say this versatile nature of being able to adapt, being able to accompany countries in their policy reforms or like very concrete reforms is something that can have tangible results. And let's say the range of interventions is also quite broad in the sense that we could provide support with a view of a legislative change, so reviewing the legislative framework in a country, or it could be simply to set up an action plan for undertaking some actions being at national scale or regional or local level, or it could be a mapping of existing situation, providing policy options and so on. But maybe to give you some a concrete illustration of what we can offer, I would refer to a project we had with Croatia, because there it was about, of course, domestic workers, a category of workers that provided care for the elderly. And the way we worked with this country is that we basically, of course, we brought in the OECD as provider of technical expertise, but the idea was to map the existing needs, to map the rights of domestic workers in Croatia, to see what was missing from different perspectives in terms of financial support, in terms of training support, in terms of well-being as well. And one of the speakers just a few minutes earlier from Belgium referred to well-being and safety of domestic workers. And of course, these are fundamental aspects we need to care about. So the DG's reform, let's say, input was to contribute to this understanding, first of all, of the situation of domestic workers in this country, to see then the way they were rewarded in terms of benefits, so cash benefits, and then, of course, as I said, their training and specific needs they had in order to be better prepared to undertake their job, specifically with regard to elderly population, and then to to see how we could make policy recommendations. And the outcome was that it was suggested to introduce a cash benefit for the domestic workers in order to make, so to reward the work they were doing, also to make the system more understandable, because previously there were different benefits that they were having. Then we had some other types of projects that were, for example, in some cases, we accompanied member states in tackling undeclared work or tackling labor exploitation, because that can happen also with respect to domestic workers. And there, The same dialogue, identifying all the relevant stakeholders is important because sometimes, you know, it's not only the national level that has competencies, but regional and local level. So bringing everybody around the table in order to identify solution, in order to identify concrete actions. Then to also work with the stakeholders in order to design other actions that would, let's say, better protect domestic workers, because it's about ownership and ownership at all levels. And this is something we think it's very important. Then also in some other instances, we had member states to review their institutional framework in order to design better monitoring systems for the situation of domestic workers, or to, for example, design and pilot and implement specific actions at local level, and were successful to accompany them in thinking how those actions could be scaled up at national level. So in a nutshell, this is the type of support, but as I said, and the way we work every year, member states are invited to submit their request to the Commission. Then there is a selection process because we have a limited financial envelope. And then at the start of every year, we kick off a new series of meetings. And actually tomorrow we will launch the dialogue with the member states to inform them about the upcoming selection period of time, because countries have until the end of October to put on the table their request. So this is, in a few words, what the service is about. And again, I would stress the demand-driven way of working of reform. So at the disposal of member states to make use of it. Thank you very much again.
Thank you very much, Raluca Painter, and I hope we have some government representatives joining us, because there's so much help offered from the EU level. And I must admit, from at least me personally as a European coordinator and being also involved in the international level, we only look at the ILO and what kind of support they can provide. So there is a lot of support that can be accessed at the EU level. And I will note, and I think we certainly will follow up, that we have to make more use of that and have to use this also as an argument for governments if they are a little bit hesitant to ratify C189 and implement it. So this is now the end of the panel, and I'm very sorry we don't have that much time for question and answers. I can see there are many questions and long ones even. So the one I followed while listening to the panelists was the first to Vera Pavlu. It's a very long comment or question in the chat. The directive, it is of the European Parliament and the Council of 20th June 2019 on transparent and predictable working conditions in the European Union, indicates in Article 1 that member states may decide not to apply the obligation in this directive to workers who have an employment relationship in which their predetermined and actual working time is equal to or less than an average of 3 hours per week in a reference period of 4 consecutive weeks. Time worked with all employers forming or belonging to the same enterprise, group, or entity shall count towards that 3-hour average. This is very legal language, but I'm absolutely sure that Vera understands what is meant here. So the comment or question is, however, households often use domestic work for a period of 3 hours per week. In the case of direct employment, can we add up the time worked with several employers, is the question. We find here the idea of occasional work also present in Convention 189, which is excluded from the Convention Article 1C, persons who perform domestic work only occasionally. Well, I mean, actually, I can quickly answer that. That term was only used in the ILO to exclude workers that are just coming in for help, like neighboring help, and that not do for a profession. So otherwise, they would be covered. Okay. So that was one. And the other one, I quickly looked because there was another one in the Q&A session. A question also from Mrs. Pavlou. Could you please say a little more about the case law that clarified the application of the EU working time regulation to domestic workers? And please do that in less than 1 minute. Thanks.
I can do both questions quickly, no worries. Thank you, Karin. So I was going to suggest that I could summarize the question, but that's fine. So the first question concerning casual employment and to what extent it's covered by the directive on transparent and predictable working conditions. First, to say that that directive, generally what it offers, first of all, it's not a new directive. It comes from previous directive, the written statement that gave employers the obligation to provide information on workers on their different conditions of work. And this exclusion, the possibility for member states to exclude casual workers was already there in the previous directive. So it's not something new that we see here. The question whether we can say that in direct employment we can add up the hours worked for different employers, I think that is not supported by the reading of the provision. So it will be difficult, I think, to make that argument. And this is generally a problem for casual workers, especially when we have conditions of direct employment. So many rights become more difficult to enforce when we have a direct recruitment, direct employment. That's why it's important there to think of professionalization and industrialization, if you want, of domestic work as a way to address also these issues with casual employment. Because if we have one bigger employer that employs domestic workers who then work for different service providers, then we wouldn't have this issue that we see here in this directive. I don't want to say that the professionalization solves all the problems, because it certainly does not, but it's one way to look at these issues with casual employment, at least. Then the other question that concerns the case law on the working time directive, just to clarify that there is no case that looks specifically on at domestic workers. However, there is one case and then subsequent case law. I will type it here on the chat. For those of you interested, they can look it up. It's a French case, it's called Isère. And there, the Court of Justice said for the first time that the definition of worker, the notion of worker under the Working Time Directive, is not the one in the Health and Safety Directive that actually excludes domestic workers, okay? So even though the Working Time Directive derives from the Health and Safety Directive, such as the Pregnant Workers Directive also, they have their own notions of workers. So the exclusion that we have in the Health and Safety Directive is not, we should not consider it replicated in these individual directives. So from there, we can, even though the case does not concern specifically domestic workers, we can make the argument that this autonomous EU law notion of worker includes also domestic workers. It will include anyone who works subordinated under someone else, who follows the directions of someone else for remuneration. And it doesn't matter whether they work 3 hours or 10 hours, because, you know, we have to look at the personal scope of each directive separately. I hope this answers the question.
Thank you so much. And I got a little hint that 2 persons raised their hand. Before I take them, I just want to let them know that I am now aware of this. There was a question to Teresa Pagana, or there was one comment more that the Portuguese system should be more kind of integrated into the discussions of the undeclared work platform. This is at least what I have in mind from the comment. And one concrete question was asked, what happens if a worker doesn't have a work permit? In other words, when the worker is undocumented and files a complaint, what are the consequences in terms of immigration laws? Please.
Okay, we can share our example in developing this awareness campaign with the platform. You already participate in the platform and the LA initiatives. And of course, we can participate and cooperate in everything that Ella or the platform finds that it will be usual to participate and show our best practices. Related to the second question, when we find a document or a domestic worker or in domestic work or any other sector that is non-declared to Social Security, it's a very severe sanction, and in this case we adopt coercive procedures. We calculate the amounts that the worker has right, and we develop the procedures in order to apply penalties in this kind of situation. In Portugal, we have a system that allows to regularize the situation of migrant people that doesn't have documents, and if they have some specific requirements, they can obtain the regularization, but it's a question related to the service of borders with the police. But what we do, it's always the same in all sectors, domestic sector, agriculture, or any kind of sector. It's a very severe sanction. We communicate to the Social Security, we calculate the amounts, and we apply penalties in order to regularize the situation. Thank you. I don't know if I was clear, if you...
I don't know. I mean, we still have, I dare that we take the two yellow hands, and then there are a lot of comments in the chat, and we are not able to really take them all up, but you can all meet on this wonderful Wonder platform and chat along the way. So I invite Kirsten Scheibe to speak, please, and ask or comment.
Sorry, this was a misunderstanding. I don't have a question. Excuse me.
Okay. Thank you. And the other one was Caroline Paré. Caroline Paré. No? Okay. Obviously, that was also not really the case. Maybe there was a lot of discussion, and I'm so sorry, I have to follow, what is said and then in the chat. So I cannot recall the details, but I would say let's spend one more minute. There was a lot of mentioning of the Belgium's voucher system, which is of course great, and I think that refers a little bit to my initial comment. It's the gold standard, and there was a little bit of a criticism coming up that it is also, on the other hand, a limited kind of tool because it's not for all domestic workers in the sector. So I'm not sure if our panelist, if he followed the kind of the chat, Peter, would you be in a position to say something to that very, very quickly?
Well, I'm in a position to say that I agree with the remarks. It's fairly obvious that we only have certain tasks within the house. So that's clearly, there are a lot of other domestic workers in Belgium which are not covered by those rules or by other rules. And indeed, there's also a secondary remark in which there are a lot of foreign workers with very little knowledge of Dutch or French here in Belgium, and that's also a problem. So that's also something we need to look into and try to rectify, and that's also something the social partners are working on. We're now talking about how can we create a better language for those people, a way to communicate, in which we also have tools for that at this point. So totally agree. It's not flawless. It's the gold standard, but even gold has another side. So I totally agree.
Thank you so much. So there's room for improvement. So I take that as the kind of conclusions from that. And I'm sorry, we are already a little bit over time. So I would like to conclude the session thanking all the panelists for their very, very interesting contributions and certainly a lot of takeaways from your contributions. And now I'm sharing my last slide for how to use the Wonder platform. And I understand from yesterday that we need the link, and it's coming up in the chat. So there is the link. And let me please quickly share my screen. Okay. So during this break, you're invited to join that Wonder platform. And well, there are a lot of instructions. So you must accept the website's request to access your camera and microphone, type your name and take your photo to enter the room. There you will see different thematic areas where you can put your profile according to your interest. And to start a conversation, simply drag your photo with your mouse or another person's photo, and a video chat bubble will create in the room, which can be joined by other people. So there was a question yesterday, there will not be any interpretation. So you have to just settle with your own language skills and hope to find another person that matches you, because the idea is to have like a coffee break where you leave the room and you meet other persons, and you don't have an interpreter there. So the next panel starts at 10:45. So